Have you ever wondered what equality really means in India? Is it just about treating everyone the same, or is it about protecting us from arbitrariness and unfair treatment by the state? From the early days of our constitution to the very latest judgments of 2025, Article 14 has been at the heart of some of the most important Supreme Court decisions. In this video, we will see how our courts have interpreted this simple promise: equality before law and equal protection of laws. Article 14 reads, "The state shall not deny to any person equality before the law or the equal protection of the laws within the territory of India." Now notice two important parts here. Equality before law, which means no special privileges. Everyone is equal in the eyes of law. Equal protection of laws, which means the state must ensure fairness and protect everyone equally, not just in substance, but also in procedure. Now let's see the cases. The first case is State of West Bengal versus Anwar Ali Sarkar, 1952. The state had passed a law called the West Bengal Special Courts Act 1950, claiming that it was meant for the speedier trial of certain offences. Under this law, the government could simply pick and choose certain cases and send them to special courts for trial. One such case involved 50 accused, including Anwar Ali Sarkar, who were charged in connection with riots and attacks on a factory. Their case was sent to a special court, they were convicted, and the matter went up to the Supreme Court. The question before the court was, can the state have unfettered discretion to decide which case goes to a special court and which one does not? The Supreme Court said no. Justice Mukherjee explained that Article 14 does not just protect substantive rights, but also procedural fairness. If the procedure itself is discriminatory, it violates equality. Justice Vivian Bose put it beautifully. The true test under Article 14 is whether fair-minded, reasonable people would consider the law just and fair. Interestingly, the then Chief Justice Sastry dissented. Next comes E.P. Royappa versus State of Tamil Nadu, 1974. Royappa was an IS officer who had served as the Chief Secretary of Tamil Nadu. But then the government transferred him to the post of Deputy Chairman of the State Planning Commission. On paper, it was still a high position, but in reality, it was seen as a post of lesser status and responsibility. Royappa challenged this, alleging that it was arbitrary, malafide, and politically motivated. He said it violated his right to equality under Articles 14 and 60. Until this case, Article 14 was understood in terms of the doctrine of reasonable classification. That is, there should be an intelligible differentia and a rational nexus with the object of the law. But Justice Bhagwati revolutionized this interpretation. He said equality is antithetic to arbitrariness. In fact, equality and arbitrariness are sworn enemies. One belongs to the rule of law and the other to the whim of absolute power. The court made it clear that you don't always need to prove discrimination between groups. If state action is arbitrary, it is automatically unequal and therefore violative of Article 14. Now fast forward to 2014, where Article 14 was used to protect the dignity of one of the most marginalized communities in India, the transgender community. In the historic Nalsa versus Union of India judgment, the National Legal Services Authority, along with activists like Lakshmi Narayan Tripathi, filed a petition asking the court to legally recognize transgender identity. They argued that denying recognition meant denying access to education, healthcare, employment, and even basic respect in society. The Supreme Court agreed. It said that Article 14 clearly guarantees equality to any person. That includes male, female, and transgender persons. Justice Radhakrishnan observed, equality includes the recognition of the individual's right to dignity and autonomy. Arbitrariness in denying equal treatment to transgender persons is impermissible under Article 14. The court declared that transgender persons must be treated as third gender and issued several binding directions. Our final stop is a very recent judgment, Arshnur Kaur versus Union of India 2025, where Article 14 was once again used to strike down gender-based discrimination. The case involved the Indian Army's Judge Advocate General branch. For years, the Army had a policy of reserving most of these posts for men while fixing a strict ceiling on how many women could be appointed. The court held that fixing a ceiling on women's entry perpetuates the status quo of discrimination. True gender neutrality means that all candidates must be judged on merit alone, without artificial caps based on gender. The court declared that the practice of confining women to restricted category, irrespective of their performance, is destructive of the concept of gender neutrality and merit. From Anwar Ali Sarkar in 1952 to Arshnur Kaur in 2025, Article 14 has remained the guardian of equality and justice. So the next time you hear the words equality before law, remember it's not just a phrase in the Constitution. It's a living shield that has protected citizens for over 70 years and continues to do so today. If you found this video helpful, make sure you like, share and subscribe, and don't forget to hit the bell icon so you never miss an update. This is Rohit Rohila and we will meet in the next one.